Well, good afternoon. We're going to go ahead and get started. I'm Steve McDonald from Rhode Island School of Design, Charles Carletta from RPI, and we're going to talk about the exciting issue of contracts. And it's much more fun than you think. So we have a little dedication, first of all. This is dedicated to all of our clients. Probably at least once a day, if not more than once a day, someone walks into my office holding a piece of paper like it's toxic waste. Or more accurately, or more commonly nowadays, they just send it to me with that awful paper clip symbol I've come to hate on email, with the sentence, could you just take a quick look at this contract and tell me if it's okay? The subtext of which is it's a 15-page, 8-point font, single-spaced contract. It's been sitting on their desk for the last 3 months. The vendor's going to be there in 20 minutes. In my fantasy world, the conversation goes something like this. Sure, just let me ask you a couple of questions. What are your goals here? What do you hope to accomplish with this contract? And I just get this strange blank look like, why would you be asking me that? Have you read the contract? What? You know? And I just hand it back to them and say, it's not okay. I don't need to know anything more about it. It's not okay. That sort of dynamic happens to lawyers on campuses all across the country every day, and it reflects a fundamental misunderstanding of what it is that contracts really are about and how to deal with contracts. So that's what we're going to talk about here. This is sort of Contracts 101. So most people, those people who are coming into my office with that toxic waste piece of paper, think of contracts as looking something like this. It's just, you know, a big trap, obviously something that nobody should have to deal with. You know, sign here and you're going to get caught. And so let's just give it to the lawyer because he can get caught in the mousetrap. From a legal standpoint, this is what a contract is. It's quite simple. It is simply an agreement between two or more people that is enforceable by law. That's all we're talking about here. Many of them do look like this. Very small font, single space, very hard to read, barely, you know, if you read it, you're wondering, is this even English we're talking about? And a lot of them do look like that. On the
Stephen, like mine.
Yours?
Like
yes.
mine.
That's what he writes. So, on the other hand, it can be as simple as this. This is a letter from something called the Boston American Baseball Club, American League Baseball Club, to some guy named Mr. George H. Ruth, dated June 11, 1918. Dear sir, we agree to pay you the sum of $1,000 if you should win 24 games, and the additional sum of $1,000 if you should win 30 ball games as a member of our club during season of 1918. Yours truly, Boston American League Baseball Club, H.H. Frazee, accepted, Mr. George H. Ruth. One sentence, and if you are from around this area, you may think this is one of the greatest contracts ever written. A single sentence, this is what gave the Babe the incentive that led to winning the World Series, and the next year Harry Frazee sold him to the damn Yankees and the Curse of the Bambino started. That's a contract. It's a letter, one sentence, that's all it needs to be a contract. It can be literally that simple. These are both contracts. People frequently say, oh, we don't have to worry about that, it's a memorandum of understanding or letter of intent. The label at the top is totally irrelevant. If there is anything in the document that is contractual in nature, where the parties have agreed to do something, even if it is only to have good faith negotiations, there is a contract to have good faith negotiations. It is not something that you can ignore. The label on the top is totally irrelevant. Just don't, if you ever are my client, I never want to hear, oh, we don't have to worry about it, it's a letter of intent. Now that you've been here, I'll hit you. I'm sure you've all seen these and signed or agreed to these kinds of contracts. The click-through agreement on some piece of software, or the terms of service that simply by accessing a website, your use of the website is subject to those terms of services. Those are contractual agreements. You're committing yourself to something, and perhaps your institution to something, every time you click through those. I'm sure you read them every time. You may not realize this, that when you buy an airplane ticket, you get that nice little, well, you used to get that nice little piece of cardboard, now you have to do it yourself. But there may actually be, in United's case, a contract that's more than 40 pages long that comes with that. You can look it up on their website. I can pretty much guarantee you would hate all the terms if you read them. But it's a contract, and by entering into that transaction, you're agreeing to a whole bunch of terms. Can be as simple as a purchase order or an invoice. On the right-hand side, we have an invoice from Lon's Car Exchange to some guy named Senator Harry S. Truman. He bought a Chrysler Royal Club Coupe and a Chrysler Windsor four-door sedan, both with radio and heater, $98 extra. You had to actually buy the heater back then. And with his trade-in for the grand sum of 2 cars for the grand sum of $2,700. Outlines the basic terms of an agreement. That's a contractual relationship between that car company and Harry Truman. He gave them help. This is a contract. It's a very difficult one to get out of. Can be as simple as this, a handshake with no written document. That can be a contract. One of my favorite contracts, this is by Roz Chast, a RISD alum, we're very proud of her, New Yorker cartoonist. You, fill in your name here, hereby grant the entire complete rights to everything you've ever thought, made, or done to Acme Company in perpetuity and throughout the universe. And even if one day they find a door in the universe that leads to a whole new non-universe place, or if somebody invents a time-stopping machine so that perpetuity no longer exists, or everything falls into a black hole and nobody knows which end is up and we're all dead anyway, so who cares? We'll still own all of those rights. So stop whining, sign or don't sign, but face reality for once in your life, because this is the way the world works, pal. Many of the contracts you have signed say essentially that. And it's a contract. Those are all, we've looked at a lot of contracts. What does it take to make a contract? It's actually a quite simple process. Legally, you need just 3 things to have a contract. You need something called an offer, something called an acceptance, and something called consideration. Legal terms, let's talk about what they are. So first of all, an offer. The person who wants to enter into a contract makes an offer, proposes something. I will do something if you do something. I will do something if you don't do something. I will pay you something if you do or don't do something. Whatever it is you want. This is a, some sort of business deal, and you, as the offeror, you are the master of your offer. You get to propose whatever it is you want to do. Next, you need the other party to accept. Okay. It can be as simple as that. It can be in any form. It could be a written document. Yes, I consent to the contract. It could be possibly a handshake. In some cases, it could simply be by going ahead and doing whatever it was that was proposed. I say to the guy next door, the kid next door, I'll give you 25 bucks to mow my lawn. He does it. He's performed the contract, and that performance was an acceptance. We had a deal, and his performance was the actual acceptance of it. So that can also be quite simple. And the last thing is consideration. In consideration of X, I do Y. In consideration of Y, you do X. Whatever it is that the parties are exchanging is consideration. There has to be some form of exchange. Now, it doesn't have to be anything in particular. There's an old common law case in which an old English court described what they called the peppercorn theory of consideration. And as long as something, even as trivial as a peppercorn, is exchanged, that's enough to bind the parties to the agreement. They have to exchange something. It doesn't have to be equal in value. It doesn't have to be a great deal. But something has to go back and forth. So the bottom line is, for a contract, basically what a contract is a bargain between 2 people in the sense that it's an agreed mutual exchange of something. It does not necessarily have to be a bargain in the sense that it's a good deal for both sides or that it's fair. There are many horrible contracts that are still perfectly enforceable contracts. They are bargains in the first sense, but not in the second. So what does it take to make a contract? What doesn't it take to make a contract? You need the offer, the acceptance, and the consideration. Well, really, pretty much nothing else. You're done. You do not need to have a negotiation. It's nice to have a negotiation, but there's no requirement in contract law that only contracts that actually are negotiated are enforceable. So, for example, those non-negotiable forms like end-user license agreements, the Google Terms of Service and the Adobe end-user license agreement, they're still enforceable. Now, if the contract is truly non-negotiable, you're given a form and, like Roz Chast says, sign it or not, but I don't care. We're not going to negotiate it. There is one thing the courts will do. If there is any term in the contract that is unconscionable, it shocks the conscience. Not unfair, not really incredibly one-sided, but truly shocks the conscience. And remember, we're talking about shocks the judge's conscience, and they're pretty jaundiced people. They've seen lots of things. So it takes an awful lot. This is, the firstborn son kind of clause. The courts will strike those things out. But the court is not going to step in and make sure that you got a good deal. It's only when, your firstborn son has been sold to somebody that they will strike that out. Bad deal, too bad. That's your problem. You agreed to it. Dilbert, the source of all wisdom. I didn't read all the shrink wrap license agreement on my new software until after I opened it. Apparently, I agreed to spend the rest of my life as a towel boy in Bill Gates' new mansion. Call your lawyer. Too late, he opened software yesterday, now he's Bill's laundry boy. Must be dangerous for lawyers to iron pants. They'd always have a hand in a pocket. I love lawyer jokes, so feel free to tell me your own. Next thing you don't need, in most cases, is a written document. There are certain things where there really does have to be a written document. Contracts for the sale of land, for example. We have this whole system of recording land transactions, and so there has to be something in writing. There are certain copyright issues where there really has to be in writing or it's not enforceable. But in most cases, it really doesn't matter if there's a written document. There is a thing called the statute of frauds that actually requires most contracts to be in writing, but there are so many exceptions to it that it's in itself pretty irrelevant. So most of the time, it really doesn't matter if you actually have a written document or not. That handshake, for most cases, will be sufficient to be a contract. If you have negotiated and you do have a written document, it's totally irrelevant whether the written document has anything to do with your negotiations. No one's going to step in and say, we want to make sure that you actually, the course of your negotiations, whatever that end result was, is in the written document. That's your job, not the court's, not anybody else's. If you have a written document and you've negotiated, and even if it is consistent with what you've talked about, it doesn't matter whether you've read it. No one's going to say it's enforceable only if you've read it. No one is going to say it's enforceable only if you've read it and you understand it. Not required that you understand the agreement you're signing. In most cases, it doesn't even matter whether you've signed the contract. Again, there are a few cases where that is a fundamental legal requirement, but for most cases, most of the kinds of things you're going to be dealing with on a day-to-day basis probably don't need to be signed in order to be enforceable. Again, it doesn't matter whether the terms of the contract are fair and reasonable. It's your job to ensure that the terms of the contract are fair and reasonable. It's nobody else's job. A court is not going to step in and save you from a bad deal that you have signed and not read and not understood and so forth. Again, Dilbert negotiations. So far, we've agreed that my company will take all of the expenses and all of the legal liabilities. Your company will get all of the revenue, patents, and public credit. I've seen many of these contracts, too. But where it says I will dig you a swimming pool with my bare hands, I will not do that. OK, you win. You can use a spoon. That would probably not shock a judge's conscience. Judges are, as I said, very jaundiced people, and that is probably, as one-sided as it is probably a perfectly enforceable legal contract. So really, the only thing that matters from contract law perspective is that the parties have manifested their mutual assent. That's a contract term. They have done something to indicate that, yes, they both intend to enter into this transaction embedded in the document or not. And that's manifested their assent from the perspective of an objective observer. If you say, yes, I agree to this contract, and you didn't show them that behind your back you had your fingers crossed, it doesn't matter. If they believe that you've accepted the contract and an outside observer would think you had done it, that's sufficient. So it's quite easy to enter into a contract. There are very few requirements to enter into a contract. Really, you just need that offer, acceptance, and consideration. Once you have that, you probably have a contract. One other thing that it doesn't take for a contract is a lawyer. The man at the head of the conference table would everyone check to see they have an attorney. I seem to have ended up with two. It's nice to have a lawyer look at contracts, but many contracts, by far the majority of contracts, are entered into without any lawyer ever looking at them, at least on your side. Some lawyer probably drafted them, all those terms of service and so forth. But there's no requirement that it be negotiated by an attorney, reviewed by an attorney, blessed by an attorney. You are perfectly capable of entering into contracts without that. And frankly, you don't always need an attorney for that. For complicated contracts, you probably do, but there are lots of really simple contracts that don't take an attorney. That Babe Ruth letter, why pay a lawyer a whole bunch of money to read that? It was pretty simple. So what should be in a contract? Well, I tend to think of what should be in a contract in the terms of sort of the journalist questions. So I think of, well, actually this. First of all, my metaphor for a contract is that the best way to think of a contract is that it is the owner's manual of the relationship between the parties. You should have this nice document that you can open it up and it will tell you exactly how things are supposed to work, how to operate this relationship. And even at the back of this document, they've thought about what happens when things break. How do you fix them? The idea being that the contract is supposed to be, the parties are supposed to have thought through exactly what their relationship is and documented it. Everyone's on a common understanding. The goal of a contract, you've probably heard the phrase, a meeting of the minds. The goal of the contract is for the parties to have thought through their transaction, their relationship, their business deal, whatever it is, and they've come to a true meeting of the minds. They both understand what it is they hope to accomplish. The more you can do that, the more you can actually think it through up front and get it documented, the less likely there will ever be a contract dispute, because the biggest source of contract disputes is when the parties don't have the same expectations. They've made assumptions, oh, they'll take care of that. But nobody asked about that. Nobody wrote it down. And the other party did not have that expectation. The more things that you can think through, the better off you are, and the far less likely you will ever even be in court or in a contract dispute. The goal is that meeting of the minds on the business relationship. So, as I said, I tend to think in the journalist terms, and so I think that a contract should answer these questions. You know, who, what, where, when, why, and how. And I add a couple more from my lawyer perspective, how much and what if. So let's talk about those. Who? Who are the parties to the contract? It's usually clear, but not always, and usually the first clause specifies who the parties are. It may also specify who are what are called third-party beneficiaries. If we have a contract between us, but there's a third party who is the true beneficiary of whatever it is, they may or may not have rights under the contract. And it would be spelled out in the document who it is, who has the rights to enforce this agreement. Fairly simple, but often missed. The what? This is the guts of any contract. What are the rights and what are the responsibilities of each of the respective parties? Who is supposed to do what? What are the specifications? You know, if it's a piece of computer software, are there a whole bunch of parameters of things it's supposed to be able to do? Whatever it is that's supposed to be. This is usually the vast bulk of any contract. A lot of clauses spelling out that, you know, somebody does something, somebody does something else. The machinery or the software or whatever meets certain specifications. Whatever those things may be, if they're important, they should be written down. Where? Sometimes it's important that a contract be performed in a particular place. If I'm hiring a performer, for a concert, for example, I want them to show up at my concert hall. They need to be in a particular place. On the other hand, it may not be relevant at all. If I'm hiring somebody to do some writing or editing for me for a grant proposal, I really don't care where they're sitting. It could be in Singapore, it probably doesn't matter. If it's important, though, we should talk about that and we should document. You know, yes, you need to show up in my concert hall for the performance. When? Also a very important thing. Several things show up here. First of all, what's the term of the contract? Is this until the work is done? Is it a one-year contract? Is it renewable? Does it renew automatically unless it's canceled? Or does it renew only if we agree to renew? Also, what are the deadlines? Are there specific deadlines, timelines, milestones where things have to occur? If those are important, those should all be spelled out as well, thought through and spelled out. Why? This is sort of a weird one. Contracts actually there doesn't have to be a clause that explains why the contract is there, but it often shows up in contracts. Old style contracts you've seen usually start off with whereas, blah, 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 that throat clearing kinds of stuff, it seems. What's actually happening there, and it can be useful, is that the parties are explaining what the general goal of this relationship is. So if there ever is a dispute and the court is trying to interpret the terms of the contract, it'll have some guidance. This is where we're heading, so I'm going to try to interpret the terms, those ambiguous terms, to head in whatever that direction is. So in my contracts, when I write them, I don't do whereas, whereas, whereas. I just, you know, it's often, you know, we agree as follows. 1, background. Here's what we hope to accomplish. Number 2, here's who's doing what, kind of thing. How? The actual method of performance may be important. If I'm hiring an artist to do a portrait, I might want an oil portrait, you know, not a charcoal sketch. I should spell that out. Sometimes, if it's truly an independent contractor thing, I don't care. I'm leaving it to their discretion, their experience and wisdom. If that's what I want, that's fine, but we should think that through. And if it's important, get that documented. How much? Obviously, always important. How much is the contract for? Who's getting paid? How much? When? What terms? Do we pay all up front? Do we pay at the end? Do we pay progress payments? can structure these things any way that you want to, but should be thought through. And then what if, finally, this is the stuff in the back of that owner's manual. If something breaks down, what happens? Can I sue you? Can I sue you only for certain kinds of things? Do I have to give you notice that you've screwed up something and an opportunity to cure? Is that opportunity 30 days, 60 days, 90 days? Any of these things, again, are fine. It doesn't really matter. From the lawyer's perspective, none of this matters. But you need to figure out something that works for you. The parties might want to have an agreement where they have agreed, we'll try to fix things ourselves, or they might want to say, no, we simply go straight to a lawsuit. You might want to talk about, is an injunction available? Are there liquidated damages, what are called liquidated damages? You don't have to worry about trying to calculate things. We just agreed ahead of time that this is the penalty for something. Now, if you've been following what I've been saying, you will agree with the statement I'm about to make, which is a contract is not a legal document. Everyone who's coming in with that toxic waste piece of paper believes that a contract is a legal document, and only lawyers understand them. Only lawyers know what to do them. A contract is a business document that is enforceable by law. The guts of the contract are the business deal. Lawyers don't know what the business deal is. All those questions I asked about, none of them are legal issues. They are business questions: who, what, where, when, why, and how. So when people come in and say, could you take a quick look at this document and tell me if it's okay, and I say, what are you hoping to accomplish, and they don't know, I know it's a problem, because it's not a legal document. It's a business document, and they have no clue what the business deal is that they're entering into. That's a problem. I can't solve that problem. I can ask a lot of questions to try to parse out the business deal, but I can't make those decisions. So I love this quote. This is what I think of when they come in. You got to be very careful if you don't know where you're going, because you might not get there. If you don't know what the business deal is, I can pretty much guarantee it's a bad contract, because you have not thought through what the business deal is. There has not been a true meeting of the minds. We are headed toward a very likely dispute at some point. My version of that is this: if you don't know what it is that you want, if you don't specify in the contract what it is you want, you're going to get whatever it is the vendor wants to give you. And that may or may not be what you were hoping for. You are simply throwing yourself on the mercy of the vendor and accepting whatever they give you, and you have no basis for dispute if it's not what you wanted. One other quote: if you've ever been on an airplane in the last 50 years, you have seen the ads for Chester Karras. Same picture. This is the original Dorian Gray. You don't get what you deserve, you get what you negotiate. Absolutely true. There is no one looking out for you but you in these deals. Your lawyer can help you with that. But the other side, who's giving you a form contract, you can be awfully sure in almost every case that it is not going to be written favorably to you. You need to negotiate it. And even if they say it's not negotiable, almost everything truly is negotiable. Your wife's asking that you rot in hell for eternity, but I think that's negotiable. You should try to negotiate these things. If it's not something you want, you need to talk about it or decide not to do it, not just simply sign and trust that you will be okay. So what should be in a contract, just to summarize what we've been talking about, there really isn't any magic language here. It doesn't matter. It doesn't have to be that dense legalese like that first contract. The real point of a contract, hopefully, is to be as clear and as complete as possible and as plain, as concise as possible. The goal, again, being to avoid misunderstandings and disputes. You want to make sure that both parties have that meeting of the minds. They have understood what their relationship was, and the closer you can get to that, it's impossible to ever anticipate absolutely everything, but the closer you can get to that, the better off you are, the less likely there will be a dispute. If there is a dispute, it is not what you personally think the contract says, it's not what the other side thinks the contract says, it's what an outside objective observer, which is, say, the judge, thinks the contract says. And the only thing the judge is going to look at in almost any case is what lawyers think of as the four corners of the document. You can come in with 50 bishops as witnesses, and they can put their hands on a stack of Bibles and say, I saw the negotiations, this is what they were supposed to do. And the judge will say, that is irrelevant evidence, I'm going to exclude it. It does not matter. The only thing that matters is that if there is a document, that written document, and the court in almost every case is going to look only at that document. The course of the negotiations, none of the other stuff matters. I frequently say, well, yeah, but that's too hard. This is an organic process, it's new. We really don't know how this relationship's going to play out, so we just can't specify details now. We just have to let it play out. To which my response is, compost is an organic process. It's a process of deterioration. If that's what you want, fine, but just understand that you have just entered into a relationship that is almost certainly going to deteriorate. You need to specify things up front. If it truly is so organic you don't know what's going to happen, you at least need to specify a process for how those decisions are going to be made, by whom they're going to be made, and not just leave it to the vendor to do whatever the vendor wants. I also hear this a lot. Oh, but we're important to them. They'd never do anything bad to us. Yeah, we talked about all these things. They didn't put in the contract, but they won't screw us. We're very important to them. And I channel, on a very rare occasion, I channel Ronald Reagan, trust but verify. If they say, oh, we won't enforce that, or we'll do this, and they won't put it in the contract, what they're telling you is, no, in fact, they won't do it. Get it in, if it's important, get it in the contract. Do not rely simply on the trust factor. I don't want to be dealing with someone I don't trust in the first place. Trust is an important part of any contract, and it is helpful. If I don't trust them, I won't enter the contract at all, but I'm also not going to rely simply on trust to protect my rights. It needs to be preferably in a written document if it's important to you. Now, at some point, you can never anticipate absolutely everything. You can't get everything pinned down, and at some point, you simply have to jump out of the airplane and hope that the parachute opens. But you do that only after you've made sure that you know that the person who packed the parachute knows what they're doing. You've taken the appropriate precautions, and so you get as close as you can to that ideal meeting of the minds. So now, with that background, we're going to look at some actual contract language, and I'm going to call on people. We're going to start off, first of all, just reading contract terms, and then we're going to go to some negotiation stuff. So take a look. What's wrong with this picture? These are actual, modified slightly, but actual terms out of contracts that people have brought to me to review. So subject to the terms and conditions herein, seller agrees to sell and deliver, buyer agrees to purchase and receive from seller buyer's full facility requirements of natural gas. The price set forth on the face of this agreement applies only to those monthly contract volumes set forth on the face hereof on a daily rateable basis. Seller shall utilize its best efforts to contract for gas in accordance with buyer's anticipated actual monthly/daily usage. However, in any month, if buyer's actual daily usage exceeds or is less than the daily rateable contract volume for that month, seller shall price the excess or deficit usage at a daily market price instead of the contract price. This is what's known as a requirements contract. You're agreeing to buy your requirements for something, whatever they turn out to be, and the seller is agreeing to provide them to whatever they agree to be. What do you think about this? Is this a good term? But you can be the first one.
Well, for openers, we have no price parameters at all. Do we all agree on that? Now, and I haven't seen this before, but Stephen is right. You see these when you're buying things as your needs require. You got to have price parameters. You got to have, actually, if you just follow his checklist, what's the price? Where's it being delivered? When? Just go through the checklist,
yeah.
Okay?
So this one, the key for me on this one, you'll notice all these things that are capitalized phrases. They're all defined terms, and if you go and read those, it's even more impenetrable language. Now, the person who brought me this contract is the guy who buys energy for RISD, and he actually had read it. He's an expert in this field. He had no clue what this meant. That was the problem with this contract. It is absolutely impenetrable language, and when you start following all the cross-references and things, it's impossible to understand what they are saying here. That's a problem. I gave him credit that he actually read it and knew that that was a problem. Got this contract, someone said, came in and said, I've read this, it looks pretty good, what do you think? Search firm is pleased, it was a letter agreement. Search firm is pleased to have this opportunity to assist you in your upcoming search for the position of associate vice president of something. The contract fee is invoiced in 3 equal installments. The first invoice is sent at the start of the search. Second and third fee installments are billed in 30-day intervals thereafter. Cancellation of this contract and any all obligations may be caused by either party. You can terminate for any reason. Upon 30 days written notice to the other party. Upon cancellation of this contract, the contract fee will be prorated to the point of cancellation. What do you think? Would anybody sign this? This is pretty much the entire agreement. You're shaking your head. Why not? Exactly. Anything else that's a problem there?
Well, that's not true. They told you they're going to get paid.
Well, yes. Well, in fact, that is my translation. The one thing we guarantee we will do here is you'll get paid. What is the timeline for searches? More than 60 days? They're paid all their fee up front. We can cancel after that, but there's no refund. And what are they going to do? So I talked to the person who sent this. Well, are they writing the position description? Are they running the ads? Are they soliciting the candidates? Are they doing the initial screening? Are they making the travel arrangements? Are they doing all the kinds of things you're asking about? I have no clue. They're happy that they get to help us. I'm delighted they're happy, and they're going to be paid up front. But this is a horrible, horrible deal. Another search firm contract we got, we proposed the following search plan. A number of things listed. Each one of those had a whole paragraph explaining what it was going to do. Goes on for 2 pages. Pretty good one, right? This is actually my translation of this one. I love these guys. And this was one where I knew instantly reading the contract, even as a lawyer, I had some trust in these people because they actually had spelled out, this was their form agreement. They had spelled out clear promises, 8 different things with text explaining in detail what it was. I could understand what they were proposing to do, and they were actual promises of actual work product that they were going to do. I had trust up front because this was not some one-sided document written by a lawyer just to hope we didn't notice. These were people who really, were making a true promise. That's a good thing. Same contract goes on. The first invoice will be sent with the contract, will be 1/3 of the total fee. That's our retainer. The second invoice will be 1/3 of the professional fee and will be sent after the committee meets with finalist candidates. The third and final invoice will be after a signed contract. Again, this is great. That's exactly, in my perspective, what it should be. They've got some upfront costs. I'm happy to give them a retainer so they can run ads and do all those kinds of things. But they're being paid basically as work is getting done, and we have, all the way to the very end, 1/3 of the money to hold on to so that if they don't do what they've promised, we've got leverage. The first contract, every bit of the leverage was in the hand of the vendor. We had 0 leverage after the first 60 days, and there was nothing they'd promised to do anyway, so we couldn't do anything. Here, they've made a number of promises, and they've given us the ability to hang on to some of the money till the very end. This is wonderful. This is a firm we've used many times. I love these people. So here's a software license. And a consultant. So design, initial setup, and implementation fee for year 1, which is the year 2011. One-time setup design fee for the software program, which includes design, implementation, programming, training, hosting, license, maintenance, and data. Lots of things they're saying they're going to do. Importation of a properly formatted database. 50% of the fee is due within 30 days upon execution. And delivery of this agreement, the remaining 50% is due on or before March 31st, 2011. What do you think about that? You're smiling, so tell me, what do you think about that? Mm-hmm.
What's your problem with that?
Regardless of what, and regardless of when. Is there any timeline? There's a timeline for money. Is there any timeline for any of those things? They've said a lot of things they're going to do, but they could do that on December 31st. I could sue them if they didn't do it on December 31st, but I'd have to wait till then. There's no timeline, no deadline, no milestone written down here. If that's important, which if you've ever been in software installation is extraordinarily important, it ought to be written down. We ought to be on the same wavelength about that. Another software consultant, time is of the essence in this agreement. Software consultants shall deliver the services on a timely basis in accordance with the time schedule set forth in the project plan. You probably can guess my translation of this one. I love these guys too. This was a software consultant where they had a timeline, those bar graph things, whatever they're called. There was an actual project plan that spelled out, in sequence how things were supposed to happen. And they said they would do it, not only that they would do it according to that, but on a timely basis in accordance with that. Time is of the essence in this agreement. That gives me something extra if they screw up to deal with them, to hold back money, to sue them for. These people are making actual commitments. And we understood, we had worked out the timeline. That's what the parties understood. Our IT people knew that's what they needed and what they could accomplish. These people promised they would do it. That's what's supposed to happen. Did I, as a lawyer, know any of this stuff? When somebody first would walk in with a piece of paper, I have no clue what our IT department needs. I can ask them, do you have a timeline? But I would have no way of knowing that. And if they haven't read the contract, if they haven't thought about the contract, again, it's clearly not okay at the beginning. By placing an order, this is an actual contract, a term of contract. By placing an order via this website on the first day of the 4th month of the year 2010 Anno Domini, you agree to grant us a non-transferable option to claim for now and forevermore your immortal soul. Should we wish to exercise this option, you agree to surrender your immortal soul and any claim you may have on it within 5 working days of receiving written notification from GameStation.co.uk or one of its duly authorized minions. You may have a slight clue in the first day of the 4th month. I mean, but this is an actual software license for GameStation, some kind of software. Basically, they were just seeing if anybody was paying attention. I think this would be one of the unconscionable terms that a court would strike down in a software agreement. But the amazing thing is, I forget if it was only hundreds of thousands or millions of people clicked yes. That's what happens. So this was an agreement for we were outsourcing something to the cloud. They were going to be dealing with certain kinds of data and so forth. Cloud service provider will not be liable for damages arising from any breach, unauthorized access, misuse of, or intrusion into the customer's data residing on cloud service provider's equipment. You sign this? You're looking intently, like skeptically. Would you sign this?
Why not? There's absolutely no liability on their part for protecting your security.
And who's in charge of the data under this? They are. I have no control. So that's exactly the conversation. I called up their lawyer and I said, excuse me, I don't really understand this clause. We're handing you our data. You're putting it on your machinery. You're in charge of it. We have no control over that. We don't do anything with it. And you're saying if you screw up, it's entirely our problem. And he said, yeah. Our insurance company told us this is a black hole liability. We can't take it on. So you think that RISD is your insurance company, basically. I strongly recommended we not do this contract. But that's what they're saying, that they have no liability even for what they do. And that probably would be enforceable as a risk transfer, a legitimate risk transfer agreement based on the risks involved and the money being paid and so forth. They could make that argument and probably would be upheld. Bill.
State laws and maybe some federal regulations might come into play on a contract like this?
That's a good point. Well, data breach notification, if they had a data breach, it might be, even with this, they might have the obligation to do the notifications if they haven't expressly excluded that. But if it cost us millions of dollars in liability for whatever they did, those statutes probably would not come in and protect us. That's us or our insurance company.
Or a data loss.
Or data loss, yeah, those kinds of things. That probably excludes that, and we're probably just toast at that point.
That's right.
So the translation of this, we have no confidence whatever in our own competence. That's basically what they're saying. Buyer beware. Vendor's liability hereunder will not exceed the fees payable within the past 12 months for the services that are the subject of the claim. We're seeing more and more of these kinds of things where they try to limit liability to what you paid them. College acknowledges that the provisions of this section represent a reasonable allocation of risk that is reflected in the fees paid by college. Now, in this particular contract, we actually were paying them nothing. This was also a particular arrangement that conceivably, although the primary liability would clearly fall if there were any tort sort of thing, it would fall on the other party, somebody could sue us, and particularly in Rhode Island where you can sue anybody for anything. So there was a real risk of us having liability, possibly millions of dollars worth of liability for what this company did. That a good deal? No. So again, we think of you as the college liability insurance company. So I had the conversation with this lawyer, and she told me, oh, I see. You want some protection? Yes, I'd like some protection. Okay, so here's the deal. We'll give you the greater of the amount you pay us, or $5,000. Eventually, I got them to say that they would add us as an additional insured on their insurance policy to up to $5 million. Even that theoretically wouldn't cover all of our liability, but it'd be so remote at that point. that I was comfortable. So that's, I mean, you have to go back and forth and negotiate to get those kinds of things. They're not volunteering that. They are trying to transfer every possible risk to you. More and more we're seeing that. Another cloud service one, cloud service provider makes no warranty of any kind, whether express, implied, statutory, or otherwise, including without limitation warranties of merchantability, fitness for a particular use, and non-infringement. You notice this is all in capital letters. Warranty disclaimers have to be in big print and in capital letters to do that. Anybody like this? No, the answer is no. You don't like this. Why not, though? You know what this means? Exactly. So this is for some kind of computer-related thing. Let's say this contract had a whole 5 pages of specifications for what the software was going to do. It doesn't matter. You can't sue them if it doesn't. What if, has anyone here been involved in the Blackboard Desire to Learn sort of thing? Blackboard being one of the bigger course management systems, they believe the Desire to Learn infringed their patent rights. One of the interesting things about patent law in the United States is if that's true, they had the ability to sue not only Desire to Learn, but everybody who used Desire to Learn. So colleges across the country got these nice letters from Blackboard saying, we're not going to sue you. We think they're infringing our patents, but we're not going to sue you yet. But if you'd like to, we'd be perfectly happy to license Blackboard to you for a reasonable fee. Contact our customer service people here. This says if that happens, not their problem. The burden of infringement shows upon you, falls upon you as well. And any kind of computer-related, software-related thing you want to have, at the very least, a warranty that it will not infringe. And if it does infringe, it's their problem, not yours. They'll take care of it. You want something that will say that if there is a data breach, that it's their problem, because they're in charge of this. This is a cloud thing. And if it's something that has certain specifications, they ought to at least warrant that the product will comply with the specifications. What this, however, says is, abandon all hope, ye who enter here. We have no idea if this thing works, and we're not even sure we own it. That in English is what that says. This is an actual, also from an actual software agreement, and this says the same thing as the other one in English. We don't claim Interactive EasyFlow is good for anything. If you think it is, great, but it's up to you to decide. If Interactive EasyFlow doesn't work, tough. If you lose $1 million because Interactive EasyFlow messes up, it's you that's out the $1 million, not us. If you don't like this disclaimer, tough. We reserve the right to do the absolute minimum provided by law, up to and including nothing. This is basically the same disclaimer that comes with all software packages, but ours is in plain English. Theirs is in legalese. We didn't really want to include any disclaimer at all, but our lawyers insisted, those damn lawyers. We tried to ignore them, but then they threatened to attack us with the attack shark, at which point we relented. That was in real software, and it literally says exactly the same thing as that earlier, the slide before this. They just had a sense of humor about it. This shows up in almost every contract. And you need to be aware of it. This agreement contains the entire agreement of the parties with respect to its subject matter and supersedes all prior negotiations, agreements, and understandings with respect thereto. This agreement may be amended only by a written document duly executed by both parties. Does anybody know what that means? Why it might or might not be important? Pardon? You have to agree on changes. Yeah, that's the second sentence. What about the first sentence? Anybody? Yeah, what's called zipper or integration clause. What this says, and there's nothing wrong with this is actually a good thing. This is saying that no matter what the course of negotiations, and if there are negotiations, there's always back and forth or whatever, the final agreement, whatever it was, is crystallized in this document. And courts enforce this. They like this because it encourages people to put everything that is important to them in the document, so that the only thing we have to look at is the document. They're telling you exactly, as you said, what I said before. Make sure you've come to a deal and written it down. So what the translation for this is, if it's not in here, it's not enforceable. So all those salesman promises, this is my other translation, everything the salesman told you is a lie. All the salesman's promises that are not in the document, they're not promises. They're not legally enforceable promises.
I want to give this one a little teeth, and then we're going to answer your question, okay? I saw an agreement once where a university bought $1 million piece of equipment, a very complicated chemical analysis piece of equipment. And the salesman suggested, actually guaranteed to the professors that this was state-of-the-art stuff, and this was a very reputable company that this salesman represented. So the college bought the equipment. For openers, the equipment didn't fit in the room. And secondly, when the professors finally got around to turning this over to the lawyers, in doing some background check, found out that the equipment was not only state-of-the-art, it was obsolete, and the manufacturer wasn't even going to make it anymore. What the salesman had managed to do was sell the last unit to the college. Now think about that in terms of that clause. The college was stuck with this unit because of the validity of the contract. And it was only because the attorneys convinced the CEO of the company that the ethics of this thing really needed to be dealt with, or the college was going to take a full-page ad out in the New York Times, that they rescinded the contract. And the company did rescind the contract, but in fact, they had it. So while Stephen and I make light of some of this stuff, the fact is that college was out $1 million.
So these clauses are good for the reasons I talked about, but it's important to understand that what it means is everything that's important to you needs to be in the document. The final deal needs to be in the document. Here's a variation of that. This agreement and all documents referenced herein is the party's entire agreement relating to its subject matter, supersedes any prior contemporaneous agreements. The terms located at a URL and referenced in this agreement, as may be modified from time to time by licensor in its discretion, are hereby incorporated by this reference. So you're all laughing, you know the translation of this one. The document I've just handed you is meaningless because they unilaterally can change it at will. It's not a contract. It appears to be a contract. It probably is for the first 5 seconds, but if they choose to totally change the terms of the deal at whatever that URL is, you've just given them the right to do that. Not a good thing. When I see those kinds of URL things, I try to get rid of them, or at the very least say, that anything that is in the agreement that conflicts with anything in the URL, the agreement prevails. So that I have something, there's some bedrock that can't be changed, even if other issues can be changed. One last variation: by signing below, you acknowledge and agree that your authorized agent advisor has provided you with a complete copy of the application and client account agreement, and that you have read, understand, and agree to those terms as they are today and as they may be amended in the future. You got that one too. So before you sign this contract, talk to her. You've agreed to whatever they may, you understand whatever it is they might choose to agree to in the future. That one, I think they, probably court might look quizzically at that one. So those are some things. Now let's talk about negotiations. Negotiation is really a very simple process. It's just talking back and forth until we get agreement that works for both parties. Some things to keep in mind. Those negotiations, as they say in The Godfather, it's not personal, it's just business. Don't get yourself too invested personally in the back and forth. It's perfectly legitimate to have different points of view. I mean, they're trying to make money, you're trying to get a good deal. And that's just the way things are. As you're doing it, though, it's very helpful to try to understand what it is the other party is really trying to accomplish. It may look like one thing on paper, but there may actually be underlying interests. And what's called interest-based bargaining, or the getting to yes stuff, if you're familiar with that, is to try to dig a little deeper. And often you can come to a real agreement if you truly understand what it is you're both trying to accomplish. You may actually not be working at cross purposes. So if you can do that, that can be helpful. So variation of that, just be aware of what it is you really need, your core interest, where sort of the drop dead point. And also if you can figure out what it is the other party, and then try to figure out if you can come to a place where you can accomplish both of those things. And the goal really in negotiation, if it truly is a true back and forth, is you're looking for the Goldilocks compromise. Something where both parties have probably given up something they'd like, but we've found some place in the middle where we both can live with it. It accomplishes enough for both of us. No contract is going to be perfect from each side's perspective. That's not possible. But you can probably the goal at least is to get to that. So in your handouts, you have a sort of a draft. I wrote this draft publishing agreement from a publisher with a little bit of attitude. And now we're going to just talk about how you might negotiate. So this is a publication for a faculty member who's going to publish an article in a journal. And he is referred to as chopped liver. Chopped liver hereby transfers all right, title, and interest in and to the article, including without limitation all intellectual property rights, including without limitation all copyright rights, to publisher, which may hereafter do whatever it pleases with the article. Publisher agrees to publish the article if and when publisher feels like it, whatever publication or format publisher may feel like placing it, with whatever edits and revisions, if any, publisher may feel like making, all in their sole and limited discretion. Right? So you've just given them everything. All property you own here and total control over it. Anybody like that? Would you agree to that? So chopped liver's version might be something like this. Publisher shall have the non-exclusive one-time right and obligation to publish the article as the lead article in the next print edition of really important journal. So not giving up property, it's now a license, it's a non-exclusive license. I could, chopped liver could shop at other journals as well. They can't edit it, they can't do anything, it has to be prominent sort of thing. Seem kind of far apart. What are they really looking for here? You might end up somewhere like this, where chopped liver gives publisher an exclusive right, retains ownership of the copyright rights, but gives the publisher an exclusive right to publish the article with standard editing. They're going to do that. There are some people who are really worried about their prose, but standard editing is going to be important. That right is limited to really important journal, not to, the first one would let them put it in a comic book. Don't want that. But also then to reprint that and reformat that for electronic and so forth. And notwithstanding the foregoing, chopped liver will continue to have the right to reproduce, distribute, and make derivative works based on the article for chopped liver's future non-commercial teaching and scholarly purposes, but not including publication in other journals. What the publication really probably wants is to make sure that they're not scooped. They've got the first rights. They want to have the reprints. But if chopped liver wants to use this in course packs, they don't really care. If chopped liver wants to extend his research into some other field and write subsequent articles, that's probably not a horrible thing. So this is something where they each get something. The goal, they've thought about it back and forth. Chopped liver doesn't simply take the form contract. They don't take his version, but they've talked about it back and forth. As consideration for this agreement, chopped liver shall have the right to purchase reprints, so that's good, of the article at whatever rate publisher in its sole and unlimited discretion deems fit to charge, but in no event less than the highest price charged to any member of the general public. The worst favored nation sort of clause here. Chopped liver may freely reproduce, distribute, and otherwise use copies of the article as he deems fit, and he doesn't have to pay publisher anything, so he can do anything he wants. Again, probably not something that the publisher is going to be wildly excited about, but there are compromises. So even if chopped liver does transfer ownership, which might be fine, he'll still have a perpetual, irrevocable, and royalty-free license. He reserves what are called sort of like shop rights to reproduce and distribute copies of the article to students enrolled in his classes in nonprofit institutions of higher education. If it might be, chopped liver is perfectly happy to give up the article, but still be able to use it in course packs. Again, back and forth, who knows? But if that's acceptable to the parties, that's fine. Chopped liver may never again use all or any part of the article, including any of the words therein, in any way without the prior written approval of publisher, which may withhold such approval for any reason or no reason at all. Sorry, you can't use it again if we don't give approval. Seems a little overbroad. Chopped liver shall be entitled to incorporate any or all of the article in any future work as he in his sole discretion deems appropriate. Now, obviously, the publisher has certain non-competition concerns here, right? That's probably what they're getting at. Chopped liver has certain needs to use his stuff again, including the word the. Maybe we talk just about the article itself, and we give them a window of exclusivity. For 3 years, chopped liver can't publish this stuff anywhere else. But after that, there's a for sale date by on anything, including journal articles. At that point, he can do that same work or works on substantially similar topics elsewhere. but they've got some protection for a period of time to reflect their investment. Might be perfectly appropriate. Again, hopefully they've thought that through. Publishers shall have a right of first refusal on all of Chopliver's future articles, other writings, and thoughts on whatever terms publisher may, in its sole and unlimited discretion, deem appropriate. You know, we like you as an author. We want to publish everything you've ever thought of, your grocery list, you know, your emails. Chopliver might simply want to strike that clause out and leave it for, you know, I've given no options, nothing to them on future works. Again, for a mid-level thing, maybe you give them a right of first refusal of some sort or an option to negotiate. So in this example, for whatever his next publication is, you'll have the exclusive right not to publish it, but to negotiate to publish it for 30 days. For 30 days, we will negotiate in good faith whether you will take this article and on what terms. And if for some reason in good faith negotiations we can't reach agreement, then I can go out, Chopliver can go out and seek other publishers. Could still talk to you, but it can also look for other publishers. That might be fair. This agreement shall be governed by and construed in accordance with the laws of Uzbekistan. Any disputes concerning this agreement must be resolved by arbitration, not litigation, in a forum and under rules to be designated by publisher in its sole and unlimited discretion. Seems kind of one-sided. This shows up in every contract: choice of law, choice of jurisdiction. So Chopliver might want any and all disputes concerning this agreement shall be resolved by Chopliver's mother in her sole and unlimited discretion. Also might be just a little one-sided. This is one that comes up a lot. For state institutions, you may actually not be able legally to consent to another state's jurisdiction. And that fight goes on. When I was at Ohio State, I had that fight all the time. Even if you're not, you may not want to agree to some far-flung jurisdiction. Everybody's always looking for the home court advantage. So you will try in the negotiations to get it to be your home court. Another gambit that often is tried is, well, let's just strike this out and we'll argue over it later, which is not a horrible thing. One thing I've been doing lately, and actually have gotten some vendors to agree to, is to say something like this. If there is a lawsuit, the plaintiff has to file in the other jurisdiction, whichever that is. So if I'm the plaintiff, I have to sue in your jurisdiction. If you're the plaintiff, you have to sue in my jurisdiction. What's nice about this clause is, first of all, going into it, I have no idea who's going to be advantaged by it. And second of all, because I have no idea who is going to be advantaged by it, it puts one more little incentive for us to try to resolve the dispute informally before filing a lawsuit. And almost always that is a good thing. Parties are almost always better off resolving, settling their disputes themselves. Court, lawyers, all that stuff is very expensive. It's time consuming, it's draining. If you can do a settlement of some sort, a resolution, a mediated thing amongst yourselves, you're going to be better off. And so this is it's one more encouragement for the parties not to file suit, because before you file suit, you have to say, I'm going to the other unfavorable jurisdiction. So I really don't want to do that. Let me see if I can work this out. I personally think that's a good thing, and I actually have gotten some vendors to accept that. So think about that. I think in the interest of time to let you talk, I will not show this. The URL is in your materials. This is about a 7-minute clip from the movie A Night at the Opera, the Marx Brothers, the contract negotiation scene. It's absolutely hysterically funny, and it is everything wrong about negotiating a contract. So I encourage you, when you go back to your hotel rooms or whatever, fire up your browser, look at this, and hopefully you will now know exactly what Groucho and Chico did wrong in their negotiations. But I'm going to give you some time to make your comments, and then we'll hopefully have some time for questions.
Well, you go ahead and ask your question while you're hot with it.
Back to the waiver disclaimer, warrants. And we come across that all the time. And the client that wants to get the contract done, most business contracts have those kind of terms in them. They're all capital letters. And they usually don't want to negotiate it. What do you advise in that situation? I mean, I advise the client that if you accept this contract, it's pretty much what you want. But most contracts have that in it. It's the firm they want to do business with. How do you deal with it?
It's very hard. So first of all, what I do is those translation things, I tell them that. I mean, you need to understand this is what it means. Do you want that? And so that one, the cloud service provider, we have no liability. The client still said, oh, but everybody uses this product. We need it. It's important to us. And so I documented that I had given this advice. But then we also had a conversation. Are there ways that you can make sure that the data that goes in there is not the kind of data that would raise data breach notification things, for example? This was for a personnel application system. Can you say on your form, do not write your social security number down. We really have no interest in it. That helps. You know, were there ways to, if it's really that important you have this particular piece of software because everybody uses it, and they're good people, are there ways that we can, not through a legal way, but through a business method way, reduce the risk? So I then had that conversation. And I made sure I documented everything so that when things fell apart, which they haven't yet, I was clear that I had given advice that this was a really stupid idea.
Now, for the rest of the audience, we have two lawyers having a conversation here, all right? Let me give you a little background, because I was going to cover this point anyway. There is a set of contract statutes that govern general terms and conditions across the country, and it's called the Uniform Commercial Code. It is the contract law. It started out as the negotiable instruments law, but it's the contract law for all 50 states. So the terms are uniform. And one of the provisions in this statute is if you print in your contract a set of words and they give you the exact words, you can actually say that this product I'm selling you won't do anything. It won't do what you're buying it for. I'm not saying it will do what you were buying it for. It won't do anything. And if it does nothing, I'm off the hook. You accept it in that manner. That is, in fact, a statutory provision. And so when you see that large print, it's there for a reason. It's not because someone's trying to get your attention. It's because they're trying to comply with the Uniform Commercial Code. And you're stuck with it. Now, I'll add one more. You will see the term as is in larger print than that. 2 words, bold print, underlined. That's a statutory provision. If you buy something as is, and it's done correctly, you get it the way it is. If it doesn't have an antenna on it, and it's supposed to, that's your problem. Now, why do I make these points at this point? And we're gonna do this quickly because Stephen and I designed this so that you could ask questions. It is this. Those of you, especially from small colleges, contracting is not something one does casually. It's something that's precise and is governed by statutory language, even when you don't recognize it. It's also governed by custom when you don't recognize it. For instance, in the publishing industry, when you hire an artist to design a trademark or a logo for you, in that industry, they own the master. You don't. So the rate you negotiate with them doesn't include that. If you want to own the master, you have to say that in that industry. And usually you pay extra for it. Now, I'm making these points because in the small college market, you don't get access to lawyers. You need to find a way to do that. And the lawyer you need access to is someone who does this kind of work. You need to think of lawyers like you think of your physicians. You go to a podiatrist for a foot problem, not an eye problem. The same is true with contracts. Stephen has made the point rather graphically. Statutory terms come to us in a variety of ways. Lawyers have taken to adding this limitation term for no reason whatsoever. We refuse to be responsible for your special, consequential, and incidental damages. You ask yourself, why would anybody put that in there? And the answer is there is no reason. Everyone has insurance. There is not an insurance policy on the face of the earth that doesn't include incidental, consequential, and special damages. But lawyers have taken to putting that in there. When it's in there, you've agreed to it. And if you've agreed to it, when there's litigation, you don't get to recover the bulk of the claim. So why would you do that? Stephen made a point of who the parties are. The contract is not between your physics department. The contract is between the university, the legal entity, and the other side are the contracting parties. I make the point because I see it every day. The arts department contracts to buy a projector for the sum of $13,000. There is no arts department. The only people that don't know that are the arts department. I want to, those of you that get involved in search contracts, the vetting process is something you want them to do. Look for that. They can cover non-discrimination issues that you cannot cover in interviews. They can ask questions you cannot ask. They can talk to people you cannot talk to. They come up with some of the people that are free of liabilities that will haunt you later on. I covered publishing contracts. General terms and conditions, I've given you hours. Feel free to modify them and use them. There are some catchphrases in there I want you to be aware of. By the way, it's the small print stuff, apropos of Stephen's earlier comments. This is a handout. You will notice that I require indemnification of us to the fullest extent required by law. That's because New York has passed, actually the Court of Appeals, our highest court, has said if you overreach on indemnification, no matter what you put in the contract, is no longer valid. You've lost it all just by overreaching. And so you cover that with buzzwords. My point here is the buzzwords are known by lawyers. And so you should try to reach out. Insurance is important. People coming to your campus to do work have to be covered. In some states, if someone comes to your campus as an independent contractor and they do work on your work and they're injured, some states label them your employee for purposes of workers' comp. You need to know that for purposes of your insurance premium, and you also want to delineate that in your contract. The other thing I've given you is some procedural stuff. I like you to have things to take home. Internally, you need to know how to delegate contractual authority. And when you have delegated authority with spending limits, put it on your website so that you eliminate the question later on in litigation about implied authority. Well, I thought he could sign the contract. Have it on your website. Here are the only people that can sign contracts at this institution. If the amount is A, the person is X. If the amount is above A, the person is Y. If the amount is above that, then it requires 2 contract signatures. Put it on your website and make sure it's there in decent sized print. I gave you a little list of questions that you use internally to ask the people who send you internally the proposal. So the physics lab wants you to buy some gas spectrometer. You want to know why. You want to know, and they've identified the vendor. They want the Brooker Model 412. Well, guess what? Varian makes one, and other people make one. And if you receive federal funding, then you're not allowed to just buy it because somebody wants it. You have to ask the questions. If this is a sole source, why is it a sole source? The people that know that are your internal people. If it's not a sole source and you receive federal monies, you can't do business that way. I've given you a list of questions you should ask internally. The other demon you want to watch out for is export control. Those of you in the research game, if you're buying a piece of equipment that is controlled means it's on a government list. There are 3 agencies that publish lists. Each of them are independent of the other. If the equipment is on one of those lists, there are some students and some faculty and some consultants that cannot use that equipment. You need to know that. Your professor needs to know that. Have them identify it up front. And at this point, I want you to be free to ask questions because everything else is all lawyer stuff. I like the way Stephen handled the dispute clause about going out of one jurisdiction into another. When you look at my list, you'll see a paragraph labeled cancellations. Those of you that do hotel work, watch out for the custom in the hotel industry. It's printed in the contract, but watch for it. If you cancel the contract, there are penalties. You pay them if you never show up. You pay them no matter what. Look for that. Sometimes you can negotiate that out. Sometimes you cannot. You'll notice I have affirmative action language in my contracts. If you receive federal funds for any reason whatsoever except student aid, you have to comply with the federal acquisition regulations. I've given you some of those in my general terms. Questions for either of us?
Could you explain a little bit more about
Consideration as part of the contract, because I thought that was like payment or a deposit or something that exchanged hands that solidified the contract.
And basically that's what it is. There has to be something flowing, something of benefit flowing in both directions, no matter what it is, payment, a peppercorn, whatever. It may be understood best in contrast. A pledge to give somebody money without anything coming back in return is technically an unenforceable contract. There are ways you can figure out a way to have some form of consideration, like in reliance on your pledge, we are going to do something, and that may fill in the gaps. But where something, the only benefit is flowing in one direction, it's unenforceable. As long as some benefit, payment, a peppercorn, whatever it is flowing in both directions, and it could be $10 million for a peppercorn, that would be fine. That's what makes it consideration, which is the third part of the contract.
So, but the shaking of a hand,
Where's the consideration in that?
If you mow my lawn, I will pay you $25. Let's shake on it. The shake is simply the okay, the acceptance.
Consideration is the flow of value. There has to be something exchanged.
at that time,
No. It has to, in a contract, it's just recited. The recitation is required, and there has to be in that recitation something that's going to change hands.
If you,
I will pay you $25 to cut my lawn. Shake on it. Contract is made. The consideration is recited.
And I will pay you $25. If you cut my lawn today, I will pay you $25 10 years from now. That will be okay. The timing is irrelevant.
Right. Okay? We're oversimplifying, of course. Anyone, other questions?
I do a lot of striking out on contracts.
Good for you.
Pens. And then initial and all that jazz, but I never feel good about that. I mean, in terms of feeling like I really have something I can enforce against that vendor after the fact. Should I be requiring that we that the vendor sort of remove that from the contract and we have a fresh document?
You can't always do that. Here's what you can't do. If we're contracting, I send you the final contract. You then scratch it out, sign it, and put it in your file. That you can't do. If you scratch it out and send it back to me and say, with a written, because you need to protect yourself here, with a written cover letter that says, here is the edited contract with my pen and ink scratch outs. Please initial them and send them back. Even if they don't come back, you've got yourself a piece of evidence that you can use later.
So what's happening is you have not actually accepted the contract. You've made a counteroffer.
That's right.
And then they need to accept it. And the performance of the contract, if they just go ahead and do it, probably would be considered acceptance. So it's ideal if you have their signed initial, but it's not strictly necessary. What Charles was talking about too, about attaching his terms and conditions and sending it back, it's really the same thing you're talking about. It's not scratched out, but it's, okay, here's our stuff. That's a counteroffer. And what's probably happening is we're now engaged in what's called the battle of the forms, and a court will figure out whose form actually prevails. But it's another way of trying to get your terms in there without a lot of unnecessary angst.
Publish your terms and conditions if you have them on your website, and refer your vendors to your website. If you do bids, attach your terms and conditions to the bid documents and then do not negotiate them. If somebody bids on a process that has your terms and conditions attached to them, then everybody's bidding on a level playing field. And I used to have this phenomenon. They would get the bid and then they say, now we need to talk about your terms. Stop! Next vendor. We're not talking about anything. You bid on it the way you got it. If you don't want it, get out of the way, the next person does. Okay? Anybody else? Isn't this wonderful stuff? They're all awake.
Yeah, they are awake. That's good. One back there.
I'm not a signer, but not an executive. My limit is like $250,000. What I get a lot is cops have already signed, these contracts, and then that they turn them in, and at that point, with $10,000, it says in there we should produce insurance and we should do, all these things. It doesn't seem like our OGC cares that this goes on, but I'm not comfortable you know, signing my name underneath it because I'm the authorized signature. In fact, the person who signed it, you know, isn't.
One quick question. Are you a public or a private institution? Private. So what Charles was talking about apparent authority is the issue. The prof might have, to the outside world, the appearance of being able to sign a contract if you've done nothing to disabuse the world of that notion. So that may already be a binding contract, even if the prof has zero authority to sign it. You can deal with that internally with the prof, but with respect to the vendor, it may be a legitimate contract. If you're the public, however, you may be able to say, depending on your state's law, that there is no apparent authority against the state. And when I was at Ohio State, I used to do this all the time. Someone would come up and say, well, you know, your coach signed a shoe contract, you can't do whatever. And I would say, I really don't care. If you want to sue the coach, feel free. I knew they weren't going to do that. But we're doing this. Well, that violates the contract. There is no contract. There is no apparent authority against the state. There are two people at The Ohio State University who have the authority to sign contracts, and if you don't know who they are, that's your problem, not mine. You don't have that advantage, though, so there's a very good chance that if you haven't taken affirmative steps to disabuse the world of who has authority, that's a real contract.
But let's start changing the culture. First, you put on your website, who does have authority on your campus? Let's start there. Secondly, send a notice out to everybody that you're not signing these things anymore. If they don't comply with some checklist that's controlled centrally, you're not putting your signature on them. I share this with you. It took me a bit to do this. I have been designated the signing authority for all hiring and all acquisitions for export control purposes. Now, here's the truth of the matter. I don't know anything about the technology involved in this. But I sent the word out, when you send me something where you're going to hire a foreign graduate, an international graduate student, or you're going to buy a new piece of equipment that's on some government list, you need to justify it or I don't sign it. If I don't sign it, you don't get it. It took a month, but it's now routine. It's going to take you a little longer than that, but
one last quick point on that, and then we're at our time. You said your general counsel's office didn't seem concerned. They probably are concerned, but they're concerned not only about the liability, they're also concerned that if they have to see every single contract, they'll just commit suicide. Because your campus is probably entering into 100 contracts a day. And for the reasons we talked about, most of what's in them has nothing to do with legal stuff. The lawyer can't be going around figuring out what the business deal is. The real solution, from my perspective, is to have a legal office and a purchasing office, and the purchasing office people know what to do. They're the professionals at buying, and they're the ones who can help sort through that stuff. And then they go to the lawyer with whatever the legal questions are, but that they would probably have signature authority for the vast bulk of the mid-range contracts.
That's correct. One more.
A large university, Illinois University, and there are, pockets of pro-signers of contracts and maybe still some try to bring it forward and educate. But one of the things that our general counsel's office does, which helps us as far as academic contracts of any sort, if a contract actually makes its way to that office and it has not come from the provost's office, from myself or from someone else, provost, another associate, it gets sent back to the person with a note that says, we need to know that the provost office, first of all, is approving of this proposal, and that's the office you have to work through first before it comes up to our office. So they're really good about
Well, that's the internal routing procedure that we both suggested. You want to have an internal process that you adhere to religiously. All right? And we'll both be outside if anyone wants to talk to us later. Thank you all. You've been great.